The High Court will today rule on whether opposition leader Raila Odinga should be compelled to run in Thursday's repeat presidential poll. The petition by Pokot South David Kosing is one more than 10 suits filed in the courts, either seeking enforcement or postponement of the Thursday election. Murimi Mwangi now reports on the intrigues in the courtroom corridors in light of the tense political climate.
As the clock ticks fast to the repeat presidential election, the judiciary, it appears, holds the last key on whether the Thursday poll will happen as planned by electoral body IEBC. And on Tuesday, the spotlight turns to Justice Chacha Mwita of the High Court as he rules whether opposition leader Raila Odinga and his running mate Kalonzo Musyoka should be barred from quitting the repeat poll, in a petition filed by Pokot South MP David Kosing, and which was heard without Odinga or Kalonzo's input after their legal team failed to file responses. This only a day after Mwita had yet another petition where former Kilome MP John Harun Mwau wants the Thursday poll cancelled, arguing that IEBC never conducted fresh nominations before gazetting the candidates. As President Uhuru Kenyatta's Jubilee Party went back to the Supreme Court, pressing for contempt charges against Odinga and Kalonzo for withdrawing from the repeat poll, terming the move a defiance to the Supreme Court order for fresh elections, following the nullification of President Kenyatta's win.
It's improbable that the court will be able to hear and determine all of them before the election. But that notwithstanding, the issues that have been put forth in these cases are those that must be pursued to their logical conclusion.
Among the other 10 pending cases in relation to the Thursday election is one filed by activist Okia Omutata to have Kenyatta hand over presidential powers to a caretaker government in the event that the repeat poll does not happen before the 31st October Supreme Court deadline.
As far as the Constitution is concerned, we have to have elections within the 60 days. But one can say where we have reached, and looking at what is happening in the country, is it fair for us to continue knowing we have a problem?
Management of the election is through a conviction of the society. If a part of the society has a conviction that it is within the law and therefore we must have an election, they probably will have a successful exercise. If a large part of the society of Kenyans do not agree that there should be an election 26, then we'll have a problem, because then it means it will be stalled by any means.
In the run-up to the nullified August 8th elections, IEBC was caught flat-footed several times over court rulings relating to key procurement decisions, including the printing of ballot papers and selection of technology provider for elections infrastructure. A state of affairs that observers argue could recur as courts dispose the repeat poll-related disputes.
It is impossible to meet a science of an election on account of the fact that it is controlled by human beings of varied backgrounds and beliefs.
Long term, we need to visit the architecture of our Constitution, see what it is we can do to address those things that can make us live in harmony as a people. The kind of architecture, Murimi, if you ask me, that will make it difficult for two communities to gang up to rule this country.
As uncertainty reigns on the Kenyan political future after the repeat presidential poll, the court corridors, it appears, is the place to watch, even as attempts at backroom talks intensify ahead of the Thursday poll. Murimi Mwangi, KTN News in Nairobi.